think is going to be a fantastic and fascinating topic for us all. A couple of housekeeping points. Please keep your camera and microphone off while Francesca's speaking, and also the event is being recorded. I know you can see that already in the Teams meeting, but just to reiterate it. So welcome, Francesca. Thank you so much for giving us the time to talk about this. I'm going to briefly introduce you, and then obviously feel free to add whatever you like as well. So Francesca represents companies and individuals in complex, high-value, multi-jurisdictional white-collar crime litigation. Francesca spent 10 years at the independent bar, defending a full spectrum of criminal law matters, but for the last 12 years focused on business crime. And since 2020, she's been with US law firm McGuireWoods, recently appeared as junior counsel in the case of FCA v. Stuart Bays. They said Bates, then I've got Bates on the brain from the post office, which was a case of insider dealing. And I think Francesca's going to talk to us about that today. So thanks again, Francesca. Do you want people to hold questions to the end or interrupt you, or what do you want to do?
I had sort of planned it on the basis of questions at the end, but I can see we're quite a small group. So if people do have questions as we go along, that's fine. And in the event that more and more people join, then it might be better leaving those to the end, but feel free to interrupt. So thank you ever so much, Gaynor, for that introduction, and thank you to Sandra for arranging this talk, and for those of you who've joined for kindly giving up your time on a Wednesday evening to listen to this. I hope you'll find it interesting. Of course, I'm now having a technical difficulty. Sorry, almost immediately. So here's the agenda. In this evening's talk, I'm going to cover the current enforcement approach of the FCA. I'm going to focus on insider dealing because I think that is a key focus now for the FCA. And then I'll look a bit at corporates who can so easily find themselves caught up in these kinds of cases because of the actions of their employees and the impact these FCA investigations have on those companies. And then I will finish up by looking at two recent cases, both from this year, one of which I was involved in. I also want to highlight throughout this talk that it's not just businesses who are regulated by the FCA or in regulated sectors like professional services, say like accountancy or law firms, that can find themselves caught up in an FCA criminal investigation. In fact, the case of Bays, which I'll mention later, was a case that really shouldn't have had anything to do with the FCA. It wasn't a regulated business involved, and Mr. Bays isn't a regulated person. It's only because it involved insider dealing that the FCA dealt with it. And it was a case that really highlighted to me that actually we all need to know about insider dealing, not just, banks and financial institutions who you might expect need to be aware of it. So that's a sort of brief rundown of what I will cover in the talk. So FCA approach to enforcement. If you cast your minds back, the FCA was formally established back on the 1st of April 2013, taking on most of its powers and functions from its predecessor, the Financial Services Authority. Since its inception, the FCA has appeared to favour civil penalties for enforcement action rather than criminal prosecutions. But generally, enforcement action, certainly criminal enforcement action, has been quite lacking. So about 65% of FCA enforcement investigations which are started end up being closed without any enforcement action being taken. For 2018 to 2019, of the cases where action was taken, less than 5% of that was criminal enforcement action. So over the sort of 10 years which the FCA has been in place rather than the FSA, it's very much focused on doing investigations, dealing with them civilly, and not so much on the criminal side. That's not to say they haven't brought any criminal actions, but they have been quite few and far between. However, that's all changed. So last year, in March 2023, Mark Stewart stood down as head of enforcement at the FCA, and he was replaced.
Sorry, can everyone go on mute, please?
And he was replaced by 2 joint heads of enforcement. So we now have Therese Chambers and Steve Smart. Therese has worked at the FCA for over 20 years, mostly in enforcement. And Steve Smart joined from the National Crime Agency, which, as I'm sure everyone on the call knows, targets serious and organised crime. He'd also previously worked for the government for about 30 years, focusing on fighting terrorism and extremism. So together, Therese and Steve, I think, are going to be quite a formidable force. And it's interesting that they're jointly now running enforcement. They've been in that role for around a year, and we are already seeing quite a lot of changes. So in a speech given in February this year, Therese Chambers made it really clear that the FCA want to deliver impactful deterrence through criminal enforcement activity. She explained that the enforcement team are going to speed up investigations and outcomes, that they want to hit wallets by imposing more fines, that they're investing heavily in a cyber forensic team. And just to put in context my comment, or her comment, in relation to fines, last year, the FCA, so in 2023, the FCA issued only 12 fines, which ranged from £3,600, so really quite a tiny fine, to over £17 million. But still, they were only averaging 1 a month. The FCA want to publicise a lot more about the work that they're doing in enforcement. No doubt people will have seen in the press over the last week or so that the FCA have come in for a lot of criticism about their plan to name and shame companies that are under investigation by them. The idea and where it came from was the FCA thought it would improve transparency, it might deter wrongdoing, it would give people more of an idea of how the FCA operate. But there's been significant pushback, including actually from MPs and government ministers as well as business, saying that to do this kind of name and shaming process would actually be putting the cart before the horse, because as we can see from some of the statistics I mentioned earlier, a lot of the time investigations end with absolutely no enforcement action whatsoever. And so some people are saying, you know, it could cause real reputational damage, and actually it may be found that there's been no wrongdoing. But whether the naming and shaming happens or not, the overall message is really clear. The FCA want to be taken seriously as a regulator. They want to ensure that criminal wrongdoings dealt with by way of prosecution in the Crown Court. And they are expecting businesses that they do regulate to cooperate. So as part of Therese's speech, she made it really, really clear that the FCA want cooperation. She was basically saying, which is true, that companies are a really key source of evidence. They have access to data about their operations, about their employees, about their investors. And she is encouraging that companies who come across wrongdoing should be reporting that to the FCA and should be assisting the FCA. They're very keen to encourage whistleblowers. Now, I, as Gaynor has already explained, am a defence lawyer who spent my whole career defending. So whilst I'm telling you this is what the FCA want to do, it's not necessarily the approach I would take, and please don't feel that I'm endorsing it. But it's time now for us to look at the FCA really as a serious prosecutorial body. So the FCA obviously have powers to prosecute a whole range of criminal offences, things like market abuse and money laundering, carrying on regulated activity when people or businesses haven't been authorised to do so. In this talk, I'm going to focus only on insider dealing. One, because I think it's a key target for the FCA, and as I've already said, it can affect a much wider range of companies than people generally realise. And two, because after quite a lack of insider dealing prosecutions over many years, with the odd one here and there, we've now had 2 prosecutions in quick succession, and we've had some arrests the FCA have publicised in the last couple of months, all based on insider dealing. And the FCA have flagged insider dealing as being a particular problem. So that's why I chose to focus on insider dealing for this talk. So what is insider dealing, for anyone who doesn't know? It's trading whilst in possession of inside information. What's inside information? Well, it's information that has to meet 4 criteria. So the first is the information relates to a particular issuer of securities, so a particular company and their shares, for example. The information too has to be specific or precise. So knowing that company A is interested in acquiring company B is not specific or precise. So it meets the first criteria, but not the second. But if you knew that actually company A had put in an offer to purchase company B, that could be specific or precise information. So that would meet the criteria. The third criteria is that this inside information, so this information is not public. But if it were made public, it would likely have a significant effect on the price of any securities. So in essence, it's having confidential information that's not known to the general market and would affect the share price if it was more widely known. In essence, it's all about cheating the financial market, so getting an unfair advantage when trading in securities. So let's look at some real examples of insider dealing. First of all, Ivan Boesky in the 1980s. So the first 2 examples are American examples, but I think they're good examples. I was trying to give a range of the kind of activity that is insider dealing. So in the 1980s, Ivan was one of New York's most successful and renowned risk arbitrageurs. He'd amassed a multi-million-dollar fortune by betting on corporate takeovers. However, all was not as it seemed, and it wasn't in fact his amazing ability to read the markets that led to his success, but instead a series of paid informers who were providing him with information that he passed off as his expertise. He was arrested in November 1986 and subsequently prosecuted for insider trading. He was provided with that inside information by a prominent investment banker of the time, Martin Siegel, of the Wall Street firm Kidder, Peabody and Company, and also another gentleman, Dennis Levine, who was an investment banker at another Wall Street firm. So that is a good example of the kind of activity that amounts to insider trading, and that we have seen in other cases. So my second example is Alexei Koval. He participated in an insider trading scheme. He was a registered investment advisor. He traded on inside information that he obtained from his co-conspirator, Mr. Peteroba, who was a former investment banker at UBS. The trading that he undertook was based on information relating to 6 mergers and acquisitions that certain UBS clients were contemplating undertaking. He purchased shares with that benefit of that inside information, generating hundreds of thousands of dollars in illicit profits. But this kind of offending doesn't just happen in America. And I just have 2 more examples I wanted to highlight, both of which are relatively recent FCA cases. So in June 2019, Fabiana Abdel Malik and Walid Shukair were sentenced each to 3 years imprisonment in respect of 5 offences of insider dealing. The FCA issued at the time a press release explaining the facts of the case. So Miss Abdel Malik was employed as a senior compliance officer at UBS. Poor UBS are getting a real pasting here today, in their London office. And she used her position to identify inside information, which she then passed on to a family friend, Walid. He was an experienced day trader of financial securities. He used the information she passed on and profited to the value of approximately £1.4 million from all the trading relating to those 5 charges. They had quite a sophisticated scheme. So they shared their information using unregistered pay-as-you-go mobile phones. They frequently changed SIM cards to try to hide evidence of their wrongdoing and communications with each other. Abdul Malik even went so far as to get a phone that looked just like her work phone, so that when she was calling him, it looked like it was a legitimate work call. And then finally, Martin Dodgson and Andrew Hind. So in May 2016, former Deutsche Bank broker and advisor to the Treasury Department in the government, Martin Dodgson was jailed for 4.5 years, and Andrew Hind for 3.5 years, following a prosecution brought by the FCA for using inside information to bet on share prices. Jurors heard at trial how Hind and Dodgson were using military-grade technology and dozens of burner phones in an attempt to cover their tracks. This was a difficult investigation for the FCA because they had to painstakingly go through more than 5 million documents, emails, spreadsheets, and notes in order to track how the inside information had been passed between the defendants. In total, there were almost the investigation costs, because it was such a complex investigation, were nearly £14 million. So these 4 examples that I have highlighted are quite extreme, but they are the kind of activity that the FCA are looking to tackle. So you might be thinking, you know, clearly not that many people are involved in this kind of offending behaviour, but actually statistics suggest that there's much more insider dealing than we ever hear about. So each year, the FCA publish a market cleanliness statistic where they look at takeover announcements in the UK, and they look to see whether or not there's been any significant or abnormal movement in share price, just before the takeover announcement. And for 2022, which is the last year I was able to get statistics for, and I've taken this from the FCA website, you'll see that there was abnormal trading in 24.6% of takeovers. So that suggests the market is really not that clean. In addition to share price, which I've just looked at, they also publish another statistic, which is the abnormal trading volume. So this is looking for abnormal increases or decreases in the amount of shares traded in the run-up to an announcement. And for 2022, it was running abnormal trading at about 8.4%. So you may think these statistics indicate that the markets are not so clean, and that insider dealing is very much something the FCA are right to be prioritising. I can't cover in this talk all the types of trading that may crop up in an insider dealing case, but on this slide, I've set out some of the common types of trading that might be undertaken with the benefit of inside information. And in the case that I was recently involved in, buying and selling shares featured, but so did spread bets. And it's almost never ending what you can do with share trading, or not even owning the underlying share, but by betting on the price of whether a share may go up or may go down. And there's lots of companies now who it's easy, you can literally open up an app or go onto a browser on the internet and sign up for an account with a whole host of different trading companies. There's these companies are regulated, but some of the products that they offer, such as spread betting, is viewed for tax purposes as an ordinary bet. So you're not taxed, you don't have to pay any capital gains on any winnings that you receive from spread bets. So it can be quite an attractive way for people to put money towards share dealing without actually having to put in vast sums or own the underlying share. So we've covered companies and the kind of employees and people who may act in an untoward fashion and end up committing insider dealing. But something that was certainly news to me, and I hope you also find it interesting, and that's why I've included it, is that the FCA have highlighted in February of this year that insider dealing is now something that they believe is being carried out by organised crime groups. So they issued a market watch alert saying that there was suspicious trading by members of organised crime groups in products whose underlying securities are listed in the UK. Forms of this kind of suspicious trading were observed in a number of different markets. An organised crime group is defined as having as its purpose, or as one of its purposes, the work of carrying on criminal activities. Organised crime group requires there to be 3 or more people acting together for it to fall within this definition. And the FCA are particularly concerned about organised crime groups being involved in spread betting, which I've touched upon, and contract for difference, which is to do with share prices and buying and selling shares, and the spread with which the price may range. So why is it important, and why did the FCA set out or particularly highlight this? They say that any group which is taking premeditated and deliberate steps to commit market abuse is a really significant risk to market integrity. And they're also concerned that this is being used to finance other types of serious crime. And so the FCA is saying to businesses that they really need to be on the lookout for this and alert to the possibility of their business being targeted by an organised crime group, specifically for the purposes of insider dealing. So the FCA have said that these organised crime groups may be contacting members of staff, particularly junior members of staff, and actually paying them to disclose inside information. Firms can take steps to try and minimise this risk. They should be communicating to all clients that the firm has got a zero tolerance approach to market abuse, that it's got a good relationship with its regulator, and that they won't hesitate to terminate any accounts where trading is suspicious. They should be putting measures in place to make sure that staff are trained. They should minimise the risk of others being able to identify those staff. For example, perhaps not advertising who's in certain teams at a particular business, and making it more difficult for junior member of staff to be targeted. In insider dealing cases, and certainly in the two cases that we are going to look at, they have concerned corporates who have not been accused of any wrongdoing, but who have found themselves caught up in these kinds of investigations. The average length of a FCA criminal investigation for the period 2022 to 2023 was 59 months, so just under 5 years. The litigation stage for that same year was on average only 9 months. In my view, this is an anomaly because the criminal courts have a really well publicised backlog of about 60,000 cases awaiting trial. So I looked then at the 2021 to 2022 litigation statistics and saw that on average, after charge for the trial to be concluded and the Crown Court proceedings to be concluded was taking an average of 40 months. This means that companies who find themselves caught up in an investigation involving the FCA, not just for insider dealing, but obviously insider dealing is one of the examples, can find themselves having to deal with an investigation in criminal proceedings for somewhere between 6 to 8 years. Often in these cases, it's a rogue individual or rogue individuals who have been committing the insider dealing for personal gain, and the employer often doesn't have a clue that this is happening. When the FCA start these investigations, and they may do it by way of a dawn raid, by arrests, by turning up at business premises, it can be very disruptive. They usually then go on to compel companies, because the FCA have lots of powers to compel, to hand over documents and to make staff members available. The cases where I have seen companies come off best, so where they have successfully cooperated with the FCA with no enforcement action then continuing against them, but only against individual staff members, have been the companies who have cooperated, but via external solicitors who have been able to negotiate and have some input into controlling how information has been handed over to the FCA. It's obviously hugely disruptive having members of staff interviewed by the FCA as suspects or as witnesses, and the companies usually end up paying for legal representation, not just for the company, but for individuals. Sometimes that's covered under directors and officers liability insurance, but sometimes the companies are having to put aside really significant sums to cover the legal costs of being caught up in an investigation, even where arguably they are then found to have done nothing wrong. It's incredibly resource heavy being on the wrong end of an investigation in terms of staff time commitments to deal with queries coming from the FCA. The legal function in a business is usually absolutely run off their feet. Staff who have to find documents, compile documents, perhaps give witness statements, need to explain why certain decisions was taken at certain times or how information was disseminated. It can take literally months or even years to send everything to the FCA that they will want. Generally, investigations generate enormous amounts of electronic and hard copy material. Companies really want to avoid being caught up in this kind of situation. So what can businesses do to protect themselves? Well, the FCA really stress the importance of firms maintaining accurate insider lists. In fact, that's a requirement under certain rules. strictly limiting access to inside information to employees who actually require that information to perform their role. Other simple precautions to take to protect price-sensitive information include things such as not seating people who have inside information close to other people who don't need to know that information. And making sure that you're telling individuals the importance of not disseminating information, marking documents with an appropriate indicator that they shouldn't be shared, or that they're sensitive, or that anyone reading it has become an insider. Use of information walls, staff training, and the most important thing for all of this, and which we've seen and we'll see when we turn to the two cases, is that records really need to be kept about all these activities. So not just in relation to insider dealing, but actually in relation to whenever I've been dealing with investigations involving corporates. Often companies have really good policies against insider dealing, or perhaps against bribery, or whatever the offence may be. And they often know what they should be doing, but it's very difficult to prove who that policy and who that training has gone to, and what steps a company has taken to enforce what they should be doing. The companies usually know what they need to do, but often have very poor record keeping around what they have done. And as I've already mentioned, because the investigations go on for so long, we get lots of situations where people say, oh, well, in 2023, we did X, Y, Z. So I assume that's what we did back in 2015, but actually there's no record of it. So the best way companies can protect themselves is really to ensure that they are keeping accurate records of what training they've done and how they are enforcing policies and to whom they applied. So I'm going to turn now to two cases which have both been dealt with by way of jury trials at Southwark Crown Court this year. So the first case is that of Mohammed Zina. So Mr. Zina worked in the conflicts resolution group for the financial investment firm Goldman Sachs International. Mr. Zina used confidential, price-sensitive information that he had gathered in the course of his work to gain an unlawful advantage when dealing in shares of 6 publicly quoted companies. He made a profit of about £140,000. So it's, in terms of profits, it's not one of the biggest cases. We heard earlier people making over £1 million. He would have made a greater profit, only by about £50,000, had the FCA not stopped him before the final share trade he was making had realised a profit. In order to finance his share dealing, he took out 3 loans from Tesco Bank, falsely claiming that the loans were to be used for setting up home or for home improvements. He then went on and used share dealing accounts under one account under his brother's name and his separate account with a different shared trading platform under his sister's name. But in total, he did 46 separate individual trades. Mr. Zina was the most junior member of the group he worked in at Goldman Sachs. He had had only 3 years' experience at the bank, one of which had been as an intern. In fact, when he was first working at the bank as an intern, he also still held down a weekend job at a supermarket. So he really was very junior, and it was unclear to me whether his internship was paid or not. At trial, his defence that he relied on was that there were failings by his employer. He claimed that Goldman Sachs had not properly trained him, that he was unaware that he was on any insider list. but the jury were not persuaded of this, really due to evidence from the bank, which allowed the FCA to prove that these claims were not true. You'll recall what I said earlier on about the FCA really looking for business to cooperate with them, and that cooperation being key. In the Zena case, several Goldman Sachs staff gave evidence, and defence counsel, so the representatives of Mr. Zena, highlighted that at least one Goldman staff member had been interviewed by the police on suspicion of contempt of court after speaking with another witness. So, although Goldman Sachs weren't found to have done anything wrong, they were certainly received reputational damage from the back of this, and clearly individuals were criticised for their behaviour in relation to this investigation and prosecution. So, as I mentioned earlier on, the best way to protect your organisation is by having a really clear paper trail, setting out the training that's been given, policies, and noting compliance with these, because if Goldman's had been able to produce that, they would have been able to cast really significant doubt on what Mr. Zena said had happened when he worked at the bank. Because he was quite young, I think he was 28 at the time of the offending, although he was 35 by the time the case was eventually dealt with, and the profit was relatively modest in the scheme of insider dealing cases, he received a lenient sentence. Now, in all of these, that's in my opinion, in all of these cases, in all of the insider dealing cases, there are terms of imprisonment passed as sentencing, really to have a deterrent effect. There have been a few cases where the term of imprisonment was suspended, but up until last week, that had only been in cases where people had pleaded guilty at an early stage. So people had accepted their wrongdoing, and then the term was suspended. But usually it's a term of imprisonment which the offender has to serve straight away. There's also, although I haven't put it on the slide, there's also significant confiscation proceedings have followed in all of these cases, where the FCA seek to recover not just the profit figure, so not just the £140,000 in Mr. Zena's case, but also the amount of money that was invested in the financial instruments in order to make the profit, plus interest. So because these cases take so long to come to court, the interest can be really, really significant. So it's very serious if you find yourself in a position like Mr. Zena. I'm going to turn now, finally, before any questions or comments, to the case of Stuart Bays. So I appeared in this case as junior counsel, but I also prepared the case as although I'm a member of the bar, I work at a firm and I have practicing certificates, I'm sure a lot of you do, which has an extension to it. So it allows me to conduct litigation. And I worked closely with Mr. Pavlos Panayi, King's Counsel, and we represented Mr. Bays. Everything that I'm going to mention here was said in open court, so obviously I'm not breaching any privilege. Additionally, the case has been really widely reported in FCA press releases and on legal websites. So Mr. Bays worked at a plastics manufacturer called RPC. They don't actually exist anymore, but not due to his work. They were taken over by an American company. And he had a job which did not naturally lend itself to having inside information. So he ran a factory site which made plastic bottles for sauces, tomato sauce and that kind of thing. It was the prosecution case that he became aware that RPC, the company he worked for, were about to buy a smaller plastics company called BPI. And using that information between the 2nd of May 2016 and the 8th of June 2016, ahead of there being a market announcement this was going to happen, He undertook a series of trades with spread bets and share purchasing so that he was able to realise a profit of just over £132,000. Mr. Bays denied that he had been in possession of inside information, but explained that he had independently worked out that BPI was a good company to purchase, that it was ripe for purchasing. And indeed, there were a lot of analyst notes, and there's lots of websites that talk about market trends and companies to watch, which also recommended BPI as a company to watch and that was ripe for acquisition. And so he said that he worked out it was a good company to invest in, but closer to the time, he worked out and really strongly believed that it would be his employer who would purchase the shares. That defence, and that he didn't have the benefit of any inside information, that defence was rejected by the jury and he was convicted. He had 2 trials. The first was a 6-week trial in April 2022, but the jury were unable to reach a decision. It was a hung jury, and then a 7-week retrial which ended in March this year, and Mr. Bays was sentenced on Friday last week. So what's interesting about Mr. Bays's case? Well, it's interesting because it's another FCA prosecution for insider dealing in quick succession after quite a gap and sporadic enforcement in relation to these kinds of cases. It's a good illustration of many of the points that I've highlighted in terms of timescale. So the trading took place in 2016. The investigation started in earnest in 2017. Charges were not brought until February 2021. And then sentencing finally took place this month, just last week. Throughout all of that period, his former employers were liaising with the FCA, supplying witnesses, supplying documents, and assisting the FCA with the case. The costs to the business in terms of time and money must be enormous. And during the course of the case, though Mr. Bays was convicted, in a similar way to the case of Zena, although we weren't aware of the defence Mr. Zena was running, Mr. Bays explained that he had never had any training on insider information. And in fact, he wasn't really an obvious person to receive such training in his role because he didn't work at head office, he wasn't involved in acquisitions. In fact, during the course of the trial, it was never actually established, and the prosecution said they didn't know how he came to be in possession of inside information, but they were able to demonstrate examples of situations he had found himself in where he may have come into contact with inside information. So it serves as quite a stark reminder to business that when you are doing your policies and thinking about insider dealing and insider lists and the ways to keep this kind of information secure and safe, you need to really be training all staff, not just those who it's obvious might come into contact with this kind of information. As I said before, it's usually a sentence of imprisonment. Mr. Bays did receive a sentence of imprisonment, but that was suspended, and it was the first case that the court and all the council teams were aware of where a suspended prison sentence was passed, despite the fact there had been a contested trial, although in this case there'd actually been 2 contested trials. But I very much take the view that there will be many more insider dealing cases coming, and that the FCA are really building up confidence in how to deal with these kinds of cases and are really determined to put the resources behind them now to bring about these kinds of convictions. So that's a whistle-stop tour really of where we're at now with insider dealing enforcement. I don't know if anyone has any questions or comments.
Doesn't sound like it, Francesca. That was really fascinating, really interesting stuff. I'm sure that a lot of the commercial organisations do a lot of training on this stuff already, or at least hopefully they do. So I think it's quite interesting to hear your comments about the need for record keeping and process around all of this. And I guess one thing is, just for me, in terms of kind of the length of time that some of these things are taking to get to court and get to through the investigation, one thing to consider is how long is your record keeping requirement. You know, because there are you know, there is going to be a situation where you potentially already have a disposal requirement from an internal process perspective, and therefore just don't have those records. So there might be a something to think about there.
Yeah, absolutely. And just in relation to that, because the investigations take so long, in our case, what we came across was that there had been a change of senior personnel, just because people retire, people move on, you know, people often don't work at companies for many, many years. And so actually the FCA ended up having to trace a number of retired people. And then they're trying to recall what they did when they handed over to someone else. And so there were sometimes discrepancies between what one person said they would have done and then what the incoming person said actually happened. And I'm sure these witnesses were attempting to assist everybody as best they could, but over such a long time frame, when you're looking at 6, 7, 8 years, people just cannot recall. So there was a lot of, I would expect I would have done X, Y, Z, but actually no evidence of it. So yeah, and it's not just insider dealing. I find this a lot when assisting corporates, that often the record keeping is just not what it should be, because people are focused much more on the day-to-day activities of the business rather than, you know, you never think you're going to need this stuff on training and policies until you do. And then it's, you know, by that point, it's a real disaster when you don't have it to hand.
Yeah. And I guess you've also got the issue with, I mean, less so now because of the legislation and regulation that came in, but not that long ago, individuals were able to conduct some form of business on their mobile phones and, you know, other forms of media. So that's been very much tightened up now, I know, but that must be a challenge as well when you're trying to kind of track a lot of these things back. I know you referred to some of that with the kind of changing of the SIM cards and what have you in the Tesco case, but
yeah, it's difficult. So in our case, they had been communicating through different internal sort of messaging software, but actually by the time the FCA thought to ask for that, quite a lot of that couldn't be retrieved, or when it is, the volume is such that the FCA don't have the resource to go through it all. So it is difficult, but I think the FCA are putting more money into their sort of cyber forensic unit, so that will no doubt assist. But how they will speed these cases up, I don't know. They have a very small, sorry, I didn't mention it earlier, but they really have quite a small criminal enforcement team. I think it's something like 7 or 8 lawyers. So to bring the volume of cases, I think they're going to need to expand that. But there have been a lot of recent hires. Actually, a lot of defence lawyers have gone, criminal defence lawyers have gone there, and they've got some really, really good people. So I'm sure that will assist them now to really bring more cases.
And presumably they need to augment their resources anyway, because 6 or 7 lawyers is not enough even for a couple of cases when you're dealing with that volume. So presumably they do that anyway with law firms already in some shape or form.
Yeah, I know they have investigation teams. I don't know exactly how they do it, but I think it just takes ages. And certainly the trial we were in, we came to know the FCA team quite well. And certainly for the period of the trial, they were solidly involved in that case. I don't know how they resource things otherwise, but like everything, you know, they've got to prioritise. They can't do everything at once. And they've got to pick the cases they really wish to pursue.
Yeah. Super. So I'm going to do one last call for questions before we let Francesca go. No? thank you again, Francesca. Really appreciate it. It's a really interesting topic for us, and very kind of timely and important for us to bear in mind. So thank you.
No, thank you ever so much.
Thank you. Take care. Bye.
Thank you. Bye.